everyone. Happy Monday morning. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. First thing I have for y'all this morning is that there is a new version of the Form I-9 that has been released. So you want to make sure that you are using the right version of that form. And the Form I-9 is the form that is an onboarding form, and it is for your new employees, and it looks at and verifies your new hire's identity and their current work authorization. So there is a new version of that form out, so just make sure that you're using the most recent version of the form. The next thing I want to talk about is the Social Security issuance of cards and numbers for our new green card holders. So we've gotten word that USCIS and the Social Security Administration are no longer going to work together to automatically, or I shouldn't say automatically, to issue the Social Security number and then mail out the cards when a green card holder's application has been approved. Right now, you can check the box on the form and say, yes, I would like the two agencies to communicate. That is coming to an end. So shortly, if you are approved for your green card, then you're going to have to follow the regular process of getting a Social Security number and a card, which is to hop on their website, and then you can make an appointment and go to your local office in order to do that. So just keep that in mind. I suspect we'll get a new Form 485 that will take out those series of questions. I think it's like 2 or 3 questions. So we don't have the new 45 yet, but I suspect with this policy change, we can be looking at a new Form 45 coming our way. The next thing I want to talk to you all about is we've heard an article recently, I think last week they issued it, from the New York Times that said that the Social Security Administration lists are now being changed to indicate that some immigrants are now being listed as deceased in the Social Security Administration rolls and in their reporting. And this is being done in conjunction with DHS as a way to get individuals that are here and that are undocumented but are using Social Security numbers as a way to get them to self-deport. So some folks are concerned that this strategy by the government will sweep up individuals who are potentially immigrants, but that are here lawfully, and also sweep up individuals that are not immigrants, that could be U.S. citizens that have a Social Security number that was issued to them shortly after their birth. So I don't think we've heard the last of this particular strategy from USCIS and DHS and ICE when it comes to taking actions against individuals that are here that are undocumented. So you may want to go in and check your Social Security record, and you can do that online. The next thing I want to talk about is we've heard a lot in the news recently about the government, DHS, is going in and canceling visas and terminating international students in SEVIS, in the SEVIS system. The SEVIS system is the system that is specifically for international students and really kind of tracking their status, which school they're at, what their degree is, all of the things related to being an international student. It is our understanding, for what we're seeing amongst colleagues, is that this seems to be happening to individuals that have criminal records, anything ranging from a minor misdemeanor and things that potentially are more severe. And also, we've seen this happen to individuals based on, or what we think is based on, their social media postings, their social media activity. These actions are also raising concerns for people. They are raising legal due process concerns, and they are raising First Amendment concerns. The due process concerns is that folks are receiving an email that essentially says your visa has been revoked and or your CVIS status has been terminated, without an opportunity to say anything, without an opportunity to say, hey, wait, what's happening? So those are the due process concerns, and the First Amendment concerns are simply that people should be able to say what their beliefs are, without it jeopardizing their visa status here in the U.S. So we've seen DHS, we've seen ICE, we've seen USCIS sort of take measures based on criminal backgrounds as well as social media activity. Lawsuits have been filed. If you currently have an employee who's on staff, if you're currently a student where this has happened to you, I really urge you to consult with your immigration attorney and see what your options are. This area dealing with international students is really changing daily. So please have a consultation, please have a conversation with your current immigration counsel who is keeping on track of all of this. We are also seeing, and we got an announcement from DHS last week. DHS is going to start actively screening social media. That is not the new piece. They're actively going to start screening social media specifically for anti-Semitic activity, and anti-Semitic comments, statements, posts. USCIS will consider anti-Semitic activity on social media and any physical in-person harassment of individuals that are Jewish when they are processing applications. So this will impact people that are applying for non-immigrant work status. This will impact individuals that are applying for green cards. This will also impact individuals that are applying for visas. So this is not simply it's not simply impacting individuals that are applying for work-related applications. It will also impact family-based green cards as well. So they were, it's a pretty broad brushstroke with this. So understand that they have carved out this niche of anti-Semitic activity on social media and physical harassment of Jewish individuals when they are looking at your immigration applications. So keep that in mind when you're applying. And if you're working with an attorney and you think you fall under this category, please have that conversation with your attorney. Next up, I have, we heard from an NPR piece that the IRS is working with DHS and ICE to finalize a deal whereby the IRS would share tax information with DHS for individuals where they are believed to be here without status, where ICE is, potentially conducting a criminal investigation of someone, or an individual has a final removal order, and that's a final deportation order. So that looks like it's going to be finalized. So, now DHS is working with the IRS to get and to gather more information on the individuals that it believes are here without status. So again, if you think that you fall into this category, you may want to have a conversation with an immigration attorney. That data, that information will most likely be shared probably quite shortly. Although they haven't given us, a specific date of whereby they are going to start sharing this information, and they haven't told us exactly what information will be shared. But we know what sort of personal information we put on tax returns. So I would guess my crystal ball kind of tells me they're going to be looking for addresses. So we'll see. We'll see if there's. We'll see what kind of happens from that. And the last thing I wanted to talk about this morning is the EB-1 Extraordinary Ability Green Card. So it is a first preference green card category. And it is for people that are of extraordinary ability in their field. And a lot of people who apply for an EB-1 Extraordinary Ability Green Card are already in O1 Extraordinary Ability, which is a non-immigrant category. They kind of really dovetail one another quite nicely. But being in O1 status isn't a requirement in order to apply for an EB-1 Extraordinary Ability Green Card. For instance, many individuals are here in the US in valid H-1B status. They are working, they're doing their thing, they're moving and grooving. But because of the backlogs in EB-2 and EB-3 categories, they've been working for quite some time, and they have now gained some notoriety in their field. They have really risen through the ranks of their field and their specific industry. If that's the case, then they might be great. An EB-1 Extraordinary Ability may be a great option for that individual who is currently in H-1B status. So when you think about the Extraordinary Ability Green Card, there's flexibility in that you don't have to be currently in O1 Extraordinary Ability non-immigrant status. So if that's something that you are curious about, you're wondering if you qualify, feel free to reach out to us. We are happy to have a consultation with you and go through your background, your resume, your CV, what you've been doing. But that's all I have for you this Monday morning. If you have any questions about your immigration case, how, the best way to hire somebody, what do you do if you have an international student who's working for you, whose CVIS has been canceled, whose visa has been canceled, you're not quite sure what to do, feel free to reach out to us. We're happy to have a consultation with you. Have a wonderful rest of your Monday and a great rest of your week.